Good morning, everybody, and welcome to the latest quarterly legal update webinar from FixFlo. And the topic of today will be no surprise to anyone, I'm sure, but the kind of our webinar and the slides today entitled "What You Don't Yet Know About Renters' Rights," the Renters' Rights Bill, and particularly a focus on repossession and the DHS.
I'm sure everyone knows everything by now.
Ah, there you go. There you go. See, look, the man that needs no introduction. That's the next slide, David. But David, good morning. Welcome as always, and great to have you with us.
Hi.
Hi.
It's a happy Thursday.
It
Happy
is a
Thursday,
happy
everyone.
birthday. Indeed, indeed. Brilliant stuff. So just before we kick
Oh,
off,
and I should have said happy Holly, in fact. For anyone who's celebrating Holly, there you go. Go and throw coloured powder at each other.
great stuff. Does that mean should we have come dressed then in that case?
Well, in coloured powder, I don't
Yeah.
think that's it's not standard business attire, no.
There you go. That's true. So just before we kick off, guys, a couple of bits of housekeeping as always. So our legal disclaimer. So please, all content presented in this webinar is intended for general information purposes only and should not be considered as legal advice or official guidance. And the more important bit of housekeeping, as always, we want these to be interactive. We've already actually had a shed load of questions come in, which is brilliant. But hopefully at the bottom of your Zoom screen, if you wiggle your mouse, you'll see a Q&A pop up, and you're able to enter a question in there. And David and I, I'm sure we'll get to them.
And to answer the one that's on the screen, the webinar is indeed recorded.
There you go.
So you don't need to ask that.
Yeah, he's done this before. He's done this before. There you go.
I'm getting too comfortable with this environment, aren't I?
Yeah, this is my part. This is, but there we go. So, guys, just to cover off in terms of topics. I know they were in the emails that we pinged out, but the focal points of today's webinar. So, key focus on grounds for possession. We're going to dive into the housing health and safety rating system and kind of what that means, what it entails, the kind of evolution of it since kind of 2004. And we'll also, very interconnected, cover Awab's law and the Decent Home Standard, two things being brought into the PRS as part of the Renters' Rights Bill, and cover those in some detail as well. But also, of course, leaving some time for question and answers at the end. But please do, like I just said, throw them at us as we proceed through. But to kick us off, grounds for possession. Now, Deb, there are a huge amount of changes and lots of A, B, Zs and things like that everywhere.
Yeah, I'm not going to pretend that I know all the grounds of possession yet. I'm getting there, but I'm having trouble.
Okay.
I'm A's and Z'd and all over the place with these.
And I guess to that end, maybe to kick us off, kind of what do you think the ones that we're most likely to see now that Section 21's gone, and regardless if that's a ground that already existed or potentially a new one, just to kind of kick us off.
Well, one of the most important things I think people should bear in mind, and I just looked at a couple of questions that are already appearing, is you must take care with what people are saying about the Renters' Rights Bill. An awful lot of people seem to have got, and I've seen an awful lot of bizarre stuff on YouTube and LinkedIn and other social media sites saying, oh, there's lots of amendments in the House of Lords and they're going to change the Renters' Rights Bill. They just really aren't. People shouldn't really be writing stories about these amendments. These are amendments that have been put down by peers. Not even peers think these things will go anywhere. I've spoken to lots of these peers, and almost all of them are saying, well, yeah, I've put down this amendment because X or Y asked me to, or encouraged me to, or I thought it was a good one. The government won't accept it. The government has a 2/3 majority in the House of Commons, is under no obligation at all to accept any amendment voted through in the House of Lords, if such an amendment was even to be voted through. Almost none of the House of Lords amendments that people are talking about are likely to make the final bill. You should assume the bill is likely to be pretty much what it is now, with a few technical alterations to correct minor issues. So people have been saying, oh, I've seen even lawyers saying this, which just really annoyed me, because they should just know better, frankly. Although, to be honest with you, lawyers know tremendously little about how the law is made, actually, ironically. I've seen lawyers posting pieces saying, oh, yeah, there's going to be changes to the rent rights law. It's going to make it much better and change its thing, and landlords are going to be able to do fixed terms or whatever. It's just not happening. So realism, people, realism, and just not everything you read on the internet is true, except for that webpage I saw that said Elvis is really alive and living on the dark side of the moon. That's true, for sure. But the rest, not so much.
There you go.
There you go. Moving on.
Moving on. Yes. I think maybe I guess the changes to landlord intends to sell, maybe ground 1A, we can start there, and the timelines around
My
that.
assumption is that the big ticket grounds are the things that have always been the big ticket things that Section 21 was used for a lot. Landlords who want to move in themselves, landlords who want to sell, rent arrears, ASB. Those are going to come up again and again and again. The reality is that the vast majority of possession claims using Section 8 are for rent arrears or ASB. The vast majority of Section 21 notices were served for rent arrears, ASB, or wanting to sell. So it is inevitable that if you look into the future and look at what grounds are being used, landlords wanting to move in, landlords wanting to sell, rent arrears and ASB are going to be the ones that will come up again and again and again. I'm sure that ground 4A will get a bit of a visitation, but probably not that much because most students will leave. And obviously other grounds will be used, and I think it'll be quite interesting to see. I think there'll be a bit of an explosion in use across quite a wide sweep of them initially, but then things will tend to settle out into a fairly well-worn series of paths. And the reality is that's how law tends to develop. You tend to get a scenario when the law changes is you get a very limited number of lawyers making lots of money, lucky me, advising on the new changes and doing a significant number of cases and appeals. And then things tend to become more commoditized, and it settles out into run-of-the-mill stuff with a much smaller number of appeals then still being taken by the same expert. So over time, initially there'll be quite a wide use of lots of grounds, but things will then tend to settle out into a fairly sort of standardized package around 4 or 5 different scenarios.
Okay.
Because that's the way the world is, unfortunately. It's quite boring a lot of the time.
No, it makes complete sense, I guess, when precedents are set and it's standardized, as you say. I know we got loads of questions coming in, which is great. We'll come to them. Just one of the key ones that someone had sent to me a couple of times before we jumped on, actually, was all around if they intend to sell, the time frame, and that prevents tenants moving in and all this kind of stuff.
I will run through all the time frames because people seem to keep getting them wrong.
They
So
do.
if you want to rely on ground 1 or ground 1A, they're very similar, actually. Obviously, different things. So ground 1, you want to move in yourself or a direct member of your family, by which I mean your spouse, civil partner, or kids. And obviously that, and a lot of people say, what happens if the property is owned by a trust or a company? Can we move in the director's kids? And the answer is no. It's only effective for landlords who are holding as individuals. So sorry if you've taken a tax benefit by doing that. That's just not going to help you. And then 1A, landlord intends to sell. So neither of these grounds can be used inside the first 12 months of occupancy. And of course, that potentially means on switchover, that may well be that there'll be lots of people who could use those grounds because the tenants have been on your application for 12 months already. You are entitled to serve a ground 1 and 1A notice after 8 months because it's a 4-month notice so that it expires at 12 months of occupancy. Okay. So there's a lot of 4, 8, and 12 in this, which seems to be confusing people. So it's a 4-month notice. You can serve it after 8 months to expire at 12 months. As soon as you have served that notice, you enter what's called the restricted period. And that restricted period runs for the 4 months of your notice period, plus a further 12 months from the date of expiry of the notice, which means 16 months in total, being 12 plus 4, for anyone who's like me at maths. I had to look it up. So that's 16 months in total, during which you are not permitted to market or license or let the property at all. You can market it for sale. You cannot market it for letting. You cannot license it for letting. You cannot let it. And nobody else can do any of those things on your behalf either. Otherwise, both of you are committing an offence. You are also liable to a civil penalty of up to £7,000. And you're also liable to a rent repayment order, which can be pursued by either the tenant you've thrown out or any tenant you've replaced them with. So notice after 8 months, 4 months notice to expire after 12 months, lockout period from date of service of notice for 16 months, during which time you cannot market the property to let, you can't let it, you can't license it, save for one exemption, which is where it's licensed to somebody who is buying it while the conveyancing goes through. That is the instant summary of 101A. Now, in practice, this may not matter because I suspect in lots and lots and lots of cases, landlords will never serve ground 1A notices. And what they will do is they'll turn to the tenant and say, I'm thinking about selling. I could serve you notice, but I would much rather come to an amicable agreement when you move out in reasonable time that suits you, and tell you what, I'm prepared to give you a couple of £1,000 to make it easy. At which point all of that restriction stuff goes away because you haven't served the notice.
There you go.
And the reason I think that people will do that is because if you flick it around and you're the tenant, what will you do? If you've been served 4 months notice to sell and someone keeps viewing the property like 3 times, so it's looking very likely they want to buy it, at the end of the 4-month period, are you going to leave? Or are you going to say to the landlord, well, you know, I am keen to leave actually, but I've spoken to local authority who said you have to take me to court. And that will take a while. And to be honest, it's going to cost me quite a lot of money to move. And it would really help if you could just, you know, give me £3,000, in which case I would be able to move quite easily in quite a short time period. So the reality being that quite a few tenants will probably say that. It's almost certainly much more likely to be in a landlord's interest to say before serving a notice, I'm planning to serve you a notice because I want to sell, but I'd rather avoid doing that. How about I do a cash for keys? Here's a deed of surrender. Here's a check. Sign this, move out, you get the check.
Interesting. I think just loads of questions, which is great, guys. Thanks so much. Just kind of adding on to something you just mentioned there. Lisa's come in with mentioning about having to wait 12 months to serve notice. Of course, asking if you can serve in the 8th month, which is great. We've cleared that piece up. You just mentioned over about the kind of switchover period, which you spoke about then. So the Section 21 notices served before the bill comes in, will they still be valid, or will a new notice need to be served?
No, notice, this is actually in the bill. Notices that are served either Section 8 or Section 21 before these provisions come into effect, then you can rely on those notices for their use it or lose it period, or 3 months after the legislation comes into effect, whichever occurs first. So Section 8 notices last for 12 months from date of service.
Mm-hmm.
So depending on when you've served it, you'll either get that 12 months or you'll get 3 months after the legislation comes into effect. And Section 21 notices last for 6 months from date of service. But again, there's the controlling timeline in most cases will be the 3 months after it comes into effect. So yes, you can rely on notices that you have served before the legislation comes into effect, but you need to get on with it. You don't need to not do what people seem to do quite often, which is sit around for 2 months wondering whether they want to go to court or not.
Interesting. Okay. And a couple of questions I think have kind of overlapped, which would be good to get your viewpoint on, or scrolling them through. So my understanding is Section 8 has to be drafted by a solicitor or lodged by a solicitor.
Not at all. Anyone can draft a Section 8 notice, but, and there's a huge but,
okay.
There is a new restriction in the Renters' Rights Bill, which means that if you serve a Section 8 notice relying on grounds, well, if the notice is deficient or defective in any way, or you rely on grounds that you didn't believe to be true or were willfully negligent as to whether they were true or not, then you are liable for a financial penalty. So, and there happens to be an exemption for solicitors that says they're not liable because, because of intricacies about legal professional privilege that I can't be bothered to waste your time with right now. I'll save you from discussions of legal professional privilege and how it works. But in practice, I suspect many agents are going to be a bit nervous about using Section 8, except for a couple of relatively well-worn structures. And probably initially nervous across the board. It's not a drop-in replacement for Section 21 for sure.
Completely. Don has come in, guys. We will try and get to as many as we can. Just the cash for keys point that you mentioned seems to got a fair bit of traction. So would it be acceptable for an agency to negotiate this with the tenant on behalf of the landlord, or could this be deemed?
It's just a surrender, like any other surrender that you might choose to do.
Okay.
Nothing in the legislation prevents you approaching a tenant nicely, politely, non-aggressively, and negotiating freely a surrender on terms. And the government has no intention to restrict that. Obviously, if you harass them and pressure them into it, then it won't be valid, and you'll be liable for numerous exciting offences.
Interesting. I'm just trying to think, Scott, scan through here. If you vacated a tenant, but the progression is taking time, I imagine this, can the buyer move in and rent during the sales progression?
Yes, I mentioned this as exception. You can enter into a license agreement with a buyer who is buying the property, and it's the one exemption to the restricted period. I'm going to answer. I'm going to steal your thunder. Sorry, Will, and answer it once popped up at least twice, because a couple of people have said, if we serve notice and the tenant serves counter notice, what does that mean? Well, no, the notices, people ask if the notices supersede each other. No, they don't. They're both valid notices. It's just the tenant's notice is going to expire first, and that will bring the tenancy to an end. But that doesn't also mean that you can relet it, because you served ground 1 or 1A notices, and as soon as you served those notices, the restricted period applied. It makes no difference that the tenant then themselves serve notice on you, because the tenant's notice was only served because you served a notice. That's why otherwise that's why the restricted period exists.
Yeah. Good to know. So I think we're going to get very good at our 4 times table.
And then I also say someone saying that if the tenant serves notice, we start working on can the tenant change their mind? Notices cannot be withdrawn as a matter of law. If a tenant serves you notice and it can't be withdrawn. The tenancy will end at the end of the notice period. There's nothing to stop you then granting a new tenancy to that tenant. And no, you can't charge fees for that, because that would be a breach of the Tenant Fees Act.
Okay, they're all interlinked. I think the other question as well, something that we had, I think I've seen it here and we had come in before, is the time restrictions in terms of for how long the property can't be let again. What if the tenant serves notice? Presumably they're kind of out the window then.
Say that again, sorry?
So the periods of time in terms of how long a property, if you're going to serve a notice to sell, cannot be let again for. Of course, this goes out the window if, say, tenant serves notice and then the landlord can try and sell it within 2 or 3 months, but of course let it out straight away after that.
Provided the landlord has not themselves served a ground 1 or 1A notice, the restriction doesn't apply. It only the triggering effect to create that restriction is the service of that notice. Okay. If you never serve that notice, regardless of the reasons that you did a deal with the tenant. I mean, if you lied blatantly to the tenant, said, I'm intending to sell, I'll give you money, that was a total lie, then obviously you put at risk the terms of the surrender agreement, and there's a possibility it could be unwound. So I would advise you not to tell a complete lie. If you said the landlord's considering selling it, and that was true, the landlord was considering selling it, and then changed their mind, then they changed their mind.
Comprehensive answer to that one. Brilliant. I'm just trying to scan through. Deb, do you do the same? Is there any you feel we haven't covered that you think you'd like?
Well, should we talk about some of the other grounds possession? Because there's quite a lot of other grounds that are relevant.
Let's crack on with that.
So I mean, some haven't changed. The ground 2 repossession by mortgage providers hasn't changed, but it's going to be a big deal for mortgage providers, because at the moment, mortgage providers set up with LPA receivers who serve Section 21s, because the LPA receiver is not acting for the mortgage provider. They're actually acting on behalf of the landlord, who's the borrower, which is how LPA receivership works. But they can't do that under ground 2. The mortgagee has to take possession and serve the notice. So that's going to change the manner in which mortgage companies deal with repos, which will have knock-on effect across quite a lot of different things in terms of their costs and how they recover them. There's a whole load of interesting grounds around the 2 ZAs, ZBs, ZCs, ZDs. They're not applicable in all cases. But the one that is particularly interesting to me is 2ZC, which is sort of a rent to rent ground, but it only allows social landlords to repossess properties on the basis they've entered into a rent to rent agreement, and the landlord above them um, it wants the property back. So one of the interesting things about the Renters' Rights Bill is it creates a very much hierarchy of rent to rent, in the social landlords and charities and supported accommodation providers have a better deal and can offer a better deal to private sector landlords on rent to rent contracts, because they can get the property back and hand it back with vacant possession, whereas a more conventional private rent to rent operator simply won't be able to promise that because they won't be able to do it, and any vacant possession clause will be voided within their agreement.
Okay. And just on that ground two piece, the notice period for ground two, just a question coming in, I've just noticed it. With the notice period, what would the notice period be for ground two?
Oh, I've got no idea. I knew you'd ask me something like that. I think it's 4 months off the top of my head.
Okay, there we go. We can come back to that one. That's fine. And I think, again, moving on, we had a ground four down there, student accommodation. That's just for PBSA for the moment.
Ground four isn't changing. It's student accommodation provided. It's not. It's out. Ground four is not PBSA. Ground four is not for PBSA at all, because PBSA will be outside the bill. Ground four is out of season student accommodation, so provided by a PBSA provider or an exempt provider. And it's normally reserved for students, but is being rented out of season to somebody else, and they want it back for students. So it's actually for educational establishments and other exempt providers. It's not going to be relevant. 4A is the new student ground, where I'm letting to a group of students who form an HMO, and therefore 1 and 2 bed properties are exempted. And where I'm giving them 4 months notice. I've given notice before the tenancy commenced. And the key point there to note is, when all this comes into effect, if you're operating a student property and you want to rely on ground 4A, you've got a month to serve notice saying, I'm going to rely on ground 4A. And of course, I would have given you notice before the tenancy commenced, but this legislation wasn't in force at that point. So you'll have a 1 month period to pick that up, as it were.
Okay.
And obviously, student landlords will need to be very alert to that point, because they'll potentially have quite a lot of work to do, depending on the size of their portfolios, in quite a short period of time.
Yeah, no, that's
I mean, that's the one area where I see the possibility of some slight tweaking. The government isn't entirely wedded to ground 4A in its current format. And the area they're potentially open to discussion about is how to deal with 1 and 2 bed HMOs. They're not particularly interested in discussing the 6 month blockout. So, for example, you can't use ground 4A if the tenants signed the contract or entered into the agreement more than 6 months before they moved in. But that's a bit of a different thing. And then 5A, 5C are all employment related. The one that I think is particularly relevant here is 5C, which is where I've let property and consequences of an employment. 5A is for agricultural workers, so it probably won't matter to most people who would attend this webinar. But 5C is for people who have let property and consequences of employment, or have let it for starter basis. So as a temporary expedient to someone who's entered a new employment and has got temporary property while they source something of their own in the area, for example. That all falls within the remit of 5C. Ground 6 is the old redevelopment ground, but just completely rebuilt. And it removes a lot of the restrictions around buying the property with tenants in place. You couldn't use ground 6 previously if you'd bought the property with tenants in place. You will be able to use it, so it's been completely remodeled. Ground 6A, and in fact, someone has asked this question. Someone has asked, will landlord, someone who's being anonymous, damn your eyes, unless your name is in fact anonymous attendee, in which case I apologize. Will a landlord have any grounds possession of a new licensing scheme comes into force and their tenancy can't comply with the conditions? Well, that is exactly what ground 6A is about. So ground 6A deals with all of those scenarios where you've been banned and need to get the property back to vacant to comply with a banning order. where you don't comply with a license, where you've had your license revoked, where you're in breach of a planning restriction. 6A covers all of those scenarios. But there is a compensation provision available if which is discretionary, of up to, I think it's 2 months rent if it's entirely your fault. Basically, it's not a brilliant trick to get your tenants out, to have you to force the local authority to revoke your license and then say, ground 6A, because you will then have to pay compensation. So it's got an anti-avoidance element to it, to stop you dealing with that. Grounds 7A and 14 are already existing antisocial behaviour grounds, just tidied up, but they're not particularly changed. The one thing that is relevant to them is the government has put in new provisions around HMOs to address concerns about houses of multiple occupation, and to say that the courts must take into account the effect on other occupiers when deciding whether to give possession. Ground 7, I don't think it's very useful, but ground 14, I think, is an area that's likely to see significant and rapid development in the law. Because I think landlords are going to have to use it. Landlords have shied away from ground 14 a lot. I don't think the courts often deal with it very well. And they've got away with it because it's mostly been social landlords using it who don't tend to get into big barneys. They just work through the process and let it ride. I don't think private sector landlords are going to be prepared to do that, or necessarily even able to do that. And I suspect there's going to be quite a bit of legal development around ground 14. And then 8, 10, 11, obviously ground 8, the classical rent arrears, mandatory ground possession. Ground 10, some rent arrears. Ground 11, persistent lateness. Notice periods increased to 4 weeks across the board there. And then ground 8, it's not 2 months arrears anymore. It'll be 3 months arrears. So in practice, that of course means if you want to rely on the mandatory ground, that is a wild and crazy 4 months worth of arrears before you turn up in court, plus whatever it takes for the court to do its thing, which is at least 7 months according to the government's figures, but actually I think it's more like 8.
Wow.
Takes you to a full happy year of potentially no rent, which is, I think, is possibly a mistake.
Yeah, no, it's talked a lot about, but it's all about picking the right tenants to ensure those things don't.
Yeah, and I think tenant choice will become an issue. But I think the other thing that people need to think about is nipping disputes in the bud. You know, some tenants stop paying rent because of disputes. If you can nip those disputes in the bud and stop those disrepair issues that cause problems occurring, that will help. And then obviously there's nothing you can do about tenants that aren't going to pay for whatever reason, but there are deals that could potentially be done in terms of why don't you just leave and I'll wipe out the rent arrears.
No, for sure. Need to slightly move on from grounds possession, but a few more questions. I'm just going to jump in here. In fact, we actually had a FixFlo customer workshop the other day about this, but Lisa, you've asked, how do we prove antisocial behavior? So these things are being logged more and more actually through the FixFlo platform we're seeing, with agents perhaps going out, snapping a photo, and of course having that automatic audit trail on FixFlo. So I guess it's always just about keeping an audited log.
How do you prove anything? I mean, how do you prove antisocial behavior? Is emails, witness statements, attendances, photographs, recordings of phone calls where they swore at you down the phone for 10 minutes.
There you go. And just going back slightly, I think, question from Chloe, I think you covered it in ground 6, but does ground 6 cover landlords where extensive decorative works are needed? I think we've got a need for an FEPC, single glazing, lack of fixed heating, etc. So it'd be good to know. So where extensive decorative works are needed, is it covered in ground 6? I'd imagine the answer is yes.
Say again, sorry?
Extensive decorative works, is that covered in ground 6? That's what it for. So
anything that requires you to have something, it has to be something you can only do with the property vacant, and it's for a significant period of time, such that a temporary 2 or 3 nights in a hotel isn't going to work.
Okay.
But you'll need a surveyor's report to that effect. You don't just wander into court and say, yeah, it's a big paint job, but that's not going to cut it. Because you could do that paint job with a tenant in place. You could just move them around the property in most cases. It's going to have to be works of extensiveness such that it is not safe for the tenant to remain in the property.
Yeah. No, makes sense.
I mean, I would always say ground six is just way more complicated than you think it is.
Okay.
And I've had some really great professional negligence claims off the back of ground six where solicitors have just done a really terrible job. And I've ended up picking up the case. But ground six is one of those grounds where you should take advice before you go down that road.
Brilliant. Thank you. Guys, thanks so much. We got loads of questions coming in. Maybe we can follow up with a piece of content coming from FixFlo, just of a Q&A answer with some of these on here, because I'm sure we're not going to be able to cover all of them, or we might come back to them at the end.
Well, I'll pick up one I've seen a couple of people ask about is company lets. Obviously,
Good.
company lets sit outside the Housing Act 88. And that means that as things currently stand, most of the Renters' Rights Bill doesn't apply. I'm pretty sure Awab's law and the Decent Home Standard will, off the top of my head, but the PRS database won't apply, the redress schemes won't apply, the overbidding rules won't apply. Obviously, grounds possession are irrelevant to company lets, but also I've seen people talk about company lets and mixing them up with rent-to-rent deals. A company let is where a company rents a property for one of their own employees. If they then into a tenancy agreement with a third party, that is not a company let, that is a rent-to-rent deal. And it may well be a tenancy. But you need to make sure that you're when you're doing a company let, you're doing them properly and doing some checks as to who's actually going to be occupying the property.
Brilliant, guys. We'll move on to the next subject matter, really. I think so. If we flick on to HHSRS, when we spoke, it was a couple of weeks ago, you used the phrase "tacked on" to the or decent home standard, kind of been tacked onto it, and I think it was quite a nice kind of kickoff point. But before that, HHSRS, what is it? Where did it come from? As a quick explainer, and then we'll dive into it.
Right. So the I mean, what we're really going to talk about is as much as the HHSRS is decent homes. The
Yep.
HHSRS is largely unchanged at the moment. The Housing Health and Safety Rating System is a system by which local authorities are allowed to enter onto property forcibly if necessary, and then require you to make improvements to it because of defined hazards, and that's based on an assessment they carry out that is meant to consider loosely scientifically, and I say loosely because it's not very scientific, the likelihood of an incident in the next 12 months, the seriousness of that incident, and therefore create a hazard score. And hazards then sit as either category 2 hazards, in which case it's up to the local authority to take action if they want to, and category 1 hazards, in which case they must take action. And then they have a range of options, from a hazard awareness notice, just telling you about a hazard, through statutory obligations on you to actually make improvements, through prohibiting the use of the property, right up to actually knocking it down, although that's a pretty extreme reaction.
There we go.
And it does happen, but not very often, I hasten to it.
Brilliant. And decent home standard, I guess, yes, as you kind of mentioned, how are they linked, how are they tacked on to each other, like I said.
Right. So the decent home standard is something that's existed in social property for a really long time. I mean, it was started, I think, in about 2002. It was revised in 2006. It's being revised again. And that's run into the sand a bit because of changes of government and so on. But it's applied to social property for a long time. And there's been a lot of discussion about moving it into the private rented sector. It's quite a low-level standard. I mean, the vast majority of people should be compliant with the decent home standard. I mean, if your property is not compliant with the decent home standard, it's pretty poor, just to be very clear. But the idea is that the decent home standard is going to be applied into the private rent sector, and the Renters' Rights Bill does do that, though the details not clear yet. But it's a prospective standard rather than a retrospective standard, in the sense that if I turn up at your property and you're not compliant with the HHSRS, then you haven't done anything wrong yet, but I can serve you a notice that requires you to do stuff. And if you don't do that stuff, then that's quite serious, and it's an offence. Conversely, if you have an HMO license, for example, and I turn up at your property and you're not compliant with the terms of the HMO license, I often get down and say, well, they didn't warn me, but they're not required to. You're required to be compliant with the rules all the time, and I can prosecute you immediately because you're not compliant. And the decent home standard, to some extent, works in the same way. So broadly, at the moment, and I'm not saying this is how it will look in the PRS, but I think it will look not dissimilar. The Decent Home Standard has three elements to it. It has an age-based repair standard. So if you've got structural elements that are more than like 60 to 80 years old, they have to not have failings in them.
Hmm.
It has a general modernity requirement. So you have to have, for example, I mean, to give you an idea how nonsense this is, you have to have an indoor toilet. You can't have an outdoor loo, which
Yeah.
sort of shows you how poor some of the standards were when this was first introduced. But you have to have a toilet with a wash hand basin on the same floor. It can't be on different floors. It must be sensibly located.
Hmm.
So toilets opening onto kitchens and things like that are not allowed. And you have to have a reasonably modern bathroom and a reasonably modern kitchen with adequate space, for example. And then
Hmm.
the third element, and I think this is the critical element, is you must not have an HHSRS Category 1 hazard in your property.
Hmm.
And as the DHS currently stands, if you fail on two of those points, that's a DHS failure. And what the government is going to do is it's created what it's called Type 1 and Type 2 decent home standard failures, which are broadly analogous to Category 1 and Category 2 hazards under the HHSRS.
Hmm.
So when a local authority officer arrives at your property, they will assess the property for the HHSRS, but they will also assess it against the decent home standard. If you have a type 2 decent home standard failure, that is dealt with just like a category 2 HHSRS hazard. If you have a type 1 DHS failure, that is dealt with just like a category 1 HHSRS hazard. But, and this is the added kicker, if you have a type 1 failure, the local authority officer can immediately impose a civil penalty of up to £7,000 on you,
Wow.
as well as also serving you with HHSRS enforcement notices.
And in terms of charging a civil penalty, I believe I'm right here, but please do correct me. That's relatively easy for them to do, is it? Compared
Yeah,
to,
sure.
yeah.
I mean, they've got policies and they must follow them, and you can contest them to the FTT. But the bit that particularly concerns me about this is that actually, in practice, local authority officers are not very good at assessing hazards.
Hmm.
And you will tend to find that a local authority officer will walk into a property, think something must be done here, will identify a hazard, and instead of going through the hazard assessment process, will simply flag that hazard as a category 1 hazard in order to comply with their own internal policy, which says we don't really care about category 2 hazards. And then they will only do the calculations and the assessment if they're actually pressed to on the basis of an appeal afterwards. And then frequently when they do so, you find they're wrong.
Okay.
And have totally crazy sort of numbers in, because it's quite hard to get a category 1 hazard. For a property to have a category 1 hazard, there's got to be a pretty reasonable chance of you dying in it over the
Hmm.
next 12 months. So for example, excess cold is often hazarded as a category 1 hazard, but actually because of the way the system works, it's quite difficult to make excess cold a category 1 hazard because it's quite hard to die from it in the UK
Hmm.
in a house.
Yeah.
Um, Falling down the stairs, if you've got no stair banisters, then yeah, you'll get category 1 hazard every day of the week, because falling down
Yeah.
the stairs kills loads and loads and loads of people. It's
Hmm.
quite dangerous. But a lot of other hazards really have a hard time meeting those quite high thresholds. And the problem is that local authority officers tend to get that wrong a lot and say things are cat 1 hazards when they're not. And in practice, most landlords don't really care because they're going to do the work. So they just do the work and they don't argue
Hmm.
a great deal with the local authority about whether it's category 1 or category 2. They just do the job.
Yeah.
Um, whereas um, uh, if it's um, uh, an issue where you can get penalized, then clearly there's much more incentive to discuss it. But the
Yeah.
other problem with that is it's not very much money. So it's quite expensive to go through the process of the tribunal. The tribunal is a cost-neutral jurisdiction. If you hire a solicitor, you won't be getting your legal fees back. So the problem is, I think a lot of landlords are going to end up paying out randomized penalties that they shouldn't really have to pay.
So surmise there maybe potentially prevention is much better than cure in this case. Um, couple of questions that have come in, all regarding the kind of category one hazards. Dishal's come in. So how does it work when a tenant doesn't ventilate properly or accordingly? We're very aware of that. Tenants been drying their clothes where they shouldn't be, not ventilating. If a category one, yeah, how does that work with the
That's
damp
part
and
of the
mold?
overall assessment. But you've got to bear in mind, and people keep coming up with this, that damp and mold growth are actually a two-way thing.
Hmm.
Um, um, Damp and mold growth occurs, yes, because tenants don't ventilate property and don't use it properly, but it also occurs because properties are cold and don't have proper ventilation. So yes, you can blame the tenants, but in many of the cases that I've seen, you can also blame the landlord.
Okay.
So no, you will not automatically get a category one hazard if your tenants are misusing the property, but you might if they aren't using it very well, but you also actually have a very cold property that doesn't have very good ventilation. So you need to make sure you're doing what you need to do yourself.
There you go. Question directly for you, David. Are you trained in HHSRS scoring?
Me personally,
Yes. Is the question.
no,
No. There you
because
go.
I'm a solicitor. God, no.
Many
But
strings to
I
the
have taken loads and loads of cases around it.
There you
Um,
go.
I mean, there is no. I mean, there are people running informal training courses, but there is no official training. I did help write quite a lot of it though, so I do know a fair bit about it.
So the answer to that could have been yes, but there we go.
No,
Not
I'm not trained in it because I'm not mad.
there you go. Interesting one from Kirsty down the bottom here. So are category one hazards limited to just within the property, or can they cover external areas, communal stairs with a handrail, that kind of thing? Where does the liability lie, if that's the case?
Well, no, I mean, obviously, Cat 1 hazards just within the property can cover external areas, but obviously they may not fall within your responsibility.
Yep. See typing an answer there, so I won't ask you that one.
Go on, keep asking.
Dash provide formal training courses in
Oh, yeah, I'm answering this. I mean,
there you go.
they do, but they're not formal. They provide very good quality, and I consider them to be excellent training courses, but there is no centrally approved, government body approved training course for HHSRS. But yeah, if you want to go and do an HHSRS training course, then yes, I think the Dash training course is excellent.
Brilliant. And hence your earlier point about local authorities and their perhaps tenuous rating of things in place.
Well, local authority officers who've been on Dash courses do tend to be much better for sure.
There you go. There's a nice plug for those.
And one thing that's quite interesting at the moment is the government is consulting, and has just started consultation on prosecutions by local authorities. It's not clear whether that will extend to civil penalties, but actually it has talked about accreditation and better processes around the manner in which local authorities penalise.
Perfect. Just moving on to a final kind of topic, and we've touched a bit on it with damp and mold and bits and pieces like that, and we've kind of gone through decent home standard. And I know it's been mentioned a few times, but it's always good to just recap these things. So Awab's law, of course, is something that's coming into the PRS as part of the Renters' Rights Bill. David Quick, as always, a quick explainer on that. A bit of background would be great to kick us off.
Yeah, so we're going to talk about the decent home standard and Awab's law. Yeah, so we've talked about DHS. Let's talk about Awab's law. So Awab's law is totally different. Awab's law is an entirely civil thing, and relates to disrepair. So in the same sense, the tenant can take a disrepair claim against the landlord as a counter to a rent arrears eviction, for example. Or as a freestanding claim for money. They will also be able to take a similar claim under Awab's law, and also presumably they will be able to take it to whatever landlord redress scheme is putatively going to exist at some future stage. But what Awab's law is about is it's originally, again, it was introduced into the social sector after the death of a young boy called Awab Bishak. And when I say introduced, it's been put into legislation, is now Section 10 Big A of the Landlord Tenant Act 1985. So I'm sure most people on here will have heard of Section 11, because that deals with landlords repairing obligations, but there's also now Section 9A, which is the Homes Fitness for Human Habitation requirement, and there will also be a Section 10 big A, which will be Awab's law, and it was introduced there. There's meant to be regulations to bring this into effect, which have not been made because they were meant to be made by the previous government, and they went and had a general election instead, and the new government is yet to get to it. But what the government is doing in the Renters' Rights Bill is extending the scope of Section 10 Big A, because it only applied to social landlords, but it's now going to apply to all PRS landlords. So what that means is that at some point regulations were made which will specify how this is going to come into effect. And what they basically do is require you to carry out investigations within a specified time period for certain types of hazard and then remedy them. Now, I can't say for sure exactly how this is going to work. All I can do is point you to the consultation done by the Sunak government on this before the election, and indicate to you that the current government has said that they'll probably do something similar, to the extent that they don't appear to be having a further consultation. Angela Rayner has said they're going to bring this into effect for damp and mold and emergency hazards for social landlords in October, with a full rollout across a wider range of hazards by 2027. And I would assume that they will do a similar thing in the private sector, but obviously a year or so further down the road. The way that the consultation was set out is it basically required you to carry out an investigation for damp and mold within 14 days of a report. You had to produce a written report within 14 days and start work within another 7 days after that. Now, I don't think those timelines are practicable in the private rented sector, because you're going to need someone with some expertise to do an inspection report. And obviously you'd have to get a builder in pretty quickly.
And we know there's lots of them at the moment around. But
yeah, there's a bit of a shortage. So I suspect they'll give a bit longer in the private rent sector. But the general principle is you will have a relatively limited time period to go into a property and do an inspection, and a relatively limited time period in order to start work. And if you don't do that and don't meet those time periods, then you potentially face a civil claim for money, and or a complaint to the redress scheme. What the government is saying is that they want to rely on the HHSRS hazard categories, but not HHSRS hazards. But they want to use the definitional categories, but it only falls within the scope of Awab's law if it creates a serious risk to an individual in that property. So it's based on the seriousness of the problem. So, for example, you're talking damp and mold. No one's going to say you've breached Awab's law because you've got a bit of mold growth around the edges of the windows where there's a bit of condensation. If, however, you've got an entire wall that's covered with black mold because you've got a major guttering problem and an exterior crack in the render, then hell yes, you'll be within the scope of Awab's law. If it's somewhere in between and you've got someone in there who you know has asthma or some other breathing difficulty, or is under treatment for, I don't know, has cancer or something that makes them particularly vulnerable, then yes, you're probably going to fall within the scope of Awab's law. So it's based on the nature of the particular occupant and their vulnerability.
Yeah, case by case.
It's a case by case assessment. So I can't give you a hard and fast answer, and I appreciate that's frustrating to people, but this is what I and lots of other people mean when we say agents have got a substantial amount of skilling up to do under the Renters' Rights Bill, which I think is, in some senses, a good thing for them, because it's makes it a much more professional job that allows you potentially to charge landlords more money for your services. But it does mean that that it's a more carefully assessed thing, and you'll have to look at things on a more case by case basis.
No, completely. Just one of the questions, sorry to come in with, so how difficult, I think you kind of touched upon this, but maybe we went across it too quickly, but how difficult is it to contend an HHSRS category 1 or 2 hazard as a landlord? You mentioned, because it's a £7,000 civil penalty, it's going to be quite a lot to contend.
How difficult is it? Entirely depends on the nature of the hazard and the quality of the scoring done by the local authority. I mean, in practice, you have to take them to the first tier tribunal. If you want to hire a lawyer, it's going to cost you more than £7,000 probably for the process.
Yeah, no,
But you
completely.
tend to find if you put in a good response early, because you can obviously write to the local authority. If you put in a good response early, local authorities will often adjust their approach. So,
Mm.
so a £7,000 penalty is the same as all current penalties. So you get a notice of intent to penalise. You've got 28 days to respond, and then they issue a final notice of penalty, and then you can take it to the tribunal. But a good quality response at an early stage often has the effect of reducing or eliminating a penalty. And I would
No,
always say to people that the problem with these things is that people leave it too late. Prompt action is critical.
no, makes complete sense. So I also kind of tacked on, is regular property inspection the best way to avoid all of these in short? And so I guess anecdotally at FixFlo, we've seen the kind of switch from the amount of reactive repairs coming through the platform, which is normally about 250,000 a month. Over the last 6 months, as particularly as the Renters' Rights Bill ramped up, we've seen a huge switch to many more planned maintenance events occurring, and one of those is inspections. So it is the easiest way to ensure that your landlord's assets best protected is to do that inspection. And we do these things through the marketplace, and we've seen a huge spike in that, as well as, of course, EICRs that are going on at the moment. So the evidence from the rest of the market would be yes, inspections is the easiest and perhaps best way to just keep on top of everything.
Yeah, I mean, it's critically important to stay aware of what's happening and how things develop. I mean, the government will produce more guidance, and you should be cautious of government guidance because it's not always correct. And some of the things the government is saying about their own bill at the moment are not, in fact, correct. But for example, I saw Baroness Taylor writing a letter saying that landlords couldn't create licenses to tenant to occupiers, and of course they can. It's just not very easy.
Mm.
So you can be uh, you can not always take everything they say entirely seriously.
No, completely. Last few minutes, let's dive into the Q&A, David. I can see. Oh, you've gone. Where was the one you were typing all about
Oh,
when
I,
tenant
I
leaves and
grabbed a few,
things
yeah.
like this? There you go. That's always good. Do you want to cover that one? Because I think it came up a couple of times before as well
Which
regarding
one was this?
one tenant leaving, sorry, within a
Yeah,
HMO.
I mean, no, I mean, the government's not fixing that. So yeah, if one tenant leaves during a period of tenancy, that terminates the tenancy for all. I mean, that's both good and bad for landlords in the sense that you'll be able to say to all the tenants, it's over, off you go. If you want to recontract, then fine. But obviously, if you're recontracting, you can set the rent to whatever number you like.
Mm-hmm.
Um, so there'll be that aspect to it. They will, of course, be entitled to go to the tribunal for 6 months on the basis that the rent is over the market, but you won't have to go through the process of Section 13 and all of that stuff. So you can recontract for a different rent,
Mm-hmm.
or you can use it to ask tenants to leave. And I expect there'll be quite a lot of landlords who will be. I mean, this is manipulated a lot by social landlords, for example. Social landlords very rarely evict for domestic violence, even though it is a ground for possession for social landlords. What they do is one person leaves saying the person remaining has been beating me up, and they go to that person and say, "That's fine. We're really sorry about that. If you could just sign this notice to quit to terminate your tenancy with us here, we'll then happily reaccommodate you in this other property over here." And then
Mm.
they reaccommodate that person. They take the notice to quit, go back to the first person and say, well, you had a joint tenancy. The other one signed a notice to quit. It's periodic. Get out. And if you don't, we'll take you to court. And they don't have to prove the domestic violence. They just use the notice to quit.
Mm.
And then they say, oh, and you're single. You're a single man because let's be fair, it is usually it is usually men.
Mm.
They then say, well, you're a single man. You're low priority, and we've had an accusation of domestic violence, so we're not going to house you. Bye.
Oh, interesting.
So
Interesting.
I expect landlords will be in a similar position. If you've got a group of tenants and you want to get rid of them and one of them's quite keen to leave, you don't actually have to buy them all off. You could just buy off one.
Yeah.
If they're thinking about going, you could say, well, I'll tell you what, I'll give you £1,000 if you just sign a notice to quit.
And it breaks everything.
Yeah.
Interesting. Um, Amber's coming here, and we mentioned kind of a lot about category 1, 2 hazards and bits and pieces. She's just asked, when would someone from the local authority come to check these items mentioned on the HHSRS, such as mold, etc.? Is it if a tenant directly reports the issue to them? Is that the most likely time that someone's actually going to come?
Local authorities are entitled to carry out direct investigation, but in practice, it's mostly investigation on complaint.
Yeah, there you go.
I mean, it's likely to happen on complaint, or if it comes to their attention through some other agency like social services or the police, or if you've applied for a license.
There you go. All right, final couple of minutes. Can one tenant join a tenancy?
I saw one, someone's asked, do we know yet if we need to issue a new assured tenancy as opposed to an addendum to ST? So
There you
so
go.
what the government has, it's actually in the transitional provisions in the bill, but people aren't really looking at them much at the moment. I do need to do that. The government is empowered to make regulations to issue a document that you will give to existing tenants, and you will have to do that within a month of conversion. And my understanding is they are going to take up that power, and so the government's going to provide some sort of document, and you will have to give it to all your existing tenants within a month. But the upside to that is you're not going to have to repaper existing ASTs with new assured periodic tenancies, or whatever you want to call them, periodic assured tenancies, whatever you wish to call them. You can give them whatever name you like.
That's really good to know. I think
Statutory assured periodics. Stats.
you're coming up for a new acronym. Is that what you're trying to do?
I don't like APT because it reminds me of the Advanced Passenger Train.
There we go. We can.
Which I'm showing my age. Half the people here be like, "You what?" But go Google it.
Okay. I myself will do that straight after this. Final things on just a couple more questions, or maybe one more to wrap us up. How does it best work? Rent-to-rent operators what happens if any change to the tenant fee ban? Go back to social behavior.
Oh, that's a good one. What happens where a current 18-month AST is the tenant paying 3 lots of 6 months advance rent? Will the advance rent be voided once the new act comes in? Yes, it will. You can keep what you've taken, but any provision that has rent in advance, once the new legislation comes into effect, will be automatically converted to a monthly payment. And there is actually a calculation mechanism with a little formula baked into the legislation. But what you basically do is you calculate the rent up for a year and divide it by 12.
Okay. Good to know. I think, yeah, maybe that's a topic for another day of this kind of changeover period, and really diving into that instruction that's come up from the government. But guys, we'll wrap it there. I guess thank you so much all for joining us. We know the Renters' Rights Bill almost had the tenant fee ban. There you go, going back to 2018-19. But the Renters' Rights Bill is intimidating, and there's a lot going on. Here at FixFlo, we'd love to know what topics you want to know next, how we can help individually. Of course, lots of the stuff, HHSRS, Awab's law, decent home standard is all catered for through the FixFlo product. So if you are FixFlo clients, I know we get clients and non-clients alike on these webinars, but we are thinking of doing a how FixFlo helps you adhere to this with ease webinar or something along those lines. It'd be great to hear from you whether that would be something of interest, and we can definitely kind of set that up. You can let us know by scanning this QR code. Let us know what topics would be good and you'd find useful, I guess, in the coming months. But also there is a survey when you close down this webinar. I'll ask for some feedback, and please do put some topics in there. But that's it for today. David, thank you. As sage-like David Smith. There you go. That's the adjective I wanted to use to describe you at the beginning, but I forgot to.
It's my day. Someone called me eminent this morning as well.
Oh, there you go. But David, it's been a pleasure as always, and speak to you soon.
Thank you very much.
Thank you.